Good day everyone, I'm Eliza Marisi Alonde of Y1PMG03 Naphtali, and I will be discussing the Article 1352 and 1353 of the Law on Obligations and Contracts. First, let's talk about the Article 1352. Under the Article 1352, it is said that contracts without cause or with unlawful cause produce no effect whatever. The cause is unlawful if it is contrary to law, morals, good customs, public order, or public policy. The following are the requisites of cause. First, it must exist at the time the contract is entered to. Second, it must be lawful. And third, it must be true or real. Absence or want of cause means that there is a total lack of any valid consideration for the contract. The following are the effect of absence of cause. First, statement in contract of a non-existent cause. Contracts without cause confer no right and produce no legal effect whatever. Thus, a contract which is absolutely simulated or fictitious is inexistent and void. When there is, in fact, no consideration, the statement of one in the contract will not suffice to bring it under the rule of Article 1353 as stating a false consideration. A contract of sale, for example, is void if the price is simulated but the act may be shown to have been in reality a donation or some other act or contract. Second is grant of right of first refusal. It is not correct to say that there is no consideration for the grant of the right of first refusal if such grant is embodied in the same contract of lease. Since the stipulation forms part of the entire lease contract, the consideration for the lease includes the consideration for the grant of the right of first refusal. In entering into the contract, the lessee is, in effect, stating that it consents to lease the premises and to pay the price agreed upon, provided the lessor also consents that should the lessor sell the leased property, then the lessee shall be given the right to match the offered price and to buy the property at that price. In other words, the rent paid by the lessee constitutes sufficient consideration for the grant of a right of first refusal. In Article 1352, it also explains the effect of failure of cause. Absence of cause should be distinguished from inadequacy of cause, which as a general rule, it is not a ground for relief, and from failure of cause, which does not render a contract void. Illegality of cause implies that there is a cause but the same is unlawful or illegal. The cause is unlawful if it is contrary to law, morals, good customs, public order, or public policy. Contracts with unlawful cause are also null and void. For example, a promise of marriage based upon carnal connection is founded on unlawful cause and therefore void, and no action can be maintained by the woman against the man therefore. Let's now proceed and talk about the Article 1353. Under the Article 1353, it is said that the statement of a false cause in contracts shall render them void if it should not be proved that they were founded upon another cause which is true and lawful. By falsity of cause is meant that the contract states a valid consideration but such statement is not true. A false cause may be erroneous or simulated. The first always produces the inexistence of a contract. If the cause is false, the contract is rendered void because the same actually does not exist. The second does not always produce this effect because it may happen that the hidden but true cause is sufficient to support the contract. If the parties can show that there is another cause and that said cause is true and lawful, then the parties shall be bound by their true agreement. Take a look at this given example. Sarah sells to Belle a parcel of land. In the deed of sale, 200,000 is stated as the price of the land. If this statement is false, then there is no contract of sale. However, if Belle can prove that the contract is founded upon another consideration, as when Belle has exchanged her car for the land, then the contract of barter or exchange shall be valid. In this case, the statement of the price is simulated because it is willfully made. Otherwise stated, there is in fact a real consideration, but the same is not the one stated in the contract. This is the end of my discussion and I hope that you learned something. Thank you.